Welcome, everyone. My name is Kevin Selzer. I'm an employee benefits attorney with Holland & Hart in Denver. My practice is even though I'm located in Denver, my practice is mainly federally based, so I work with employers all across the country, with employees everywhere. My practice area in employee benefits, really, you could boil it down into probably 4 subcategories, although it may be a bit broader than that. Health and welfare plans, we consult on those a lot, and that's going to be the bulk of our presentation today. Executive compensation issues, I work on retirement plans, and then I also advise on tax reporting and withholding issues. So as I mentioned, today I'll primarily be covering healthcare reform issues from an employee benefits perspective. I understand that I think we have a webinar scheduled for maybe September on healthcare reform issues from the provider perspective. So tune back in for that if you're interested. This slide just kind of gives you an overview of our discussion topics. You can see we're heavily weighted on the healthcare reform side of things. Player pay, we'll talk for 8 to 10 slides on that. Employer reporting rules, the 90-day waiting period. Those 3 things are relatively recent updates. We had regs issued and final regs on player pay, I believe in February. Employer reporting rules, and I'm specifically referring to reporting under Section 6055 and 6056. There is employer reporting obligation under healthcare reform for W-2 reporting that's been in effect for a couple of years, but today we'll be focusing on the individual and employer mandate reporting. The 90-day waiting period, we had final regs, I think, again, that was either February or March on that, and then followed up with proposed regs at the same time, and then we had final regs again, clarifying a few issues just here in the last month with respect to that issue. We'll also cover other healthcare reform issues, and then finally I have a brief slide at the end to cover executive compensation issues, specifically with respect to 409A. Okay, so we've got a slide on terminology here at the beginning. You know, lots of what I talk about has different names for it, so I thought it would be good to kind of cover this. And also, there are some acronyms that I'll be using. If there's one thing that a tax lawyer likes more than a facts and circumstances analysis, it's probably an acronym. Our laws have acronyms. The defined terms under the laws have acronyms, and so forth. So you do want to remember the acronyms I have bolded on this page under the player pay rules. These 4 items listed here, the ALE, the FTE, MEC, and MB, those all relate to player pay, and you'll want to pay attention to those because some of my slides will use those acronyms. And so if you need to bookmark this page as a glossary, go ahead and do that. Based on the fact that we need a glossary, you can tell we're going to have some fun today. Okay. So this slide kind of gives you a big picture timeline of healthcare reform. And so remember, when I refer to healthcare reform, I'm referring to really a collection of laws under that healthcare reform umbrella and not a single law. And more on why that's important to remember on the next slide. But here you can see, so 2010 was kind of the first wave that we had under healthcare reform. And then 2014 was really supposed to be the second big wave. Now, I've only listed 2010 and 14 here, and that isn't to say that there haven't been other laws effective in the years not listed here, but these are kind of more the laws that are receiving more attention. And so in 2010, we had a lot of reform requirements, and then 14 was scheduled to have a lot as well. So on the individual mandate, beginning in 2014, that became effective. This is what the Supreme Court ruled on 2 years ago when it found that it was constitutional. And that mandate, and since, doesn't require individuals to have health coverage. So, you know, an individual is not going to go to jail for failing to have health coverage. Simply, they'll have to pay a penalty. That penalty will be paid on their annual tax return. And just a note that if you won't be imposed, there won't be a penalty imposed if your gap in coverage is less than 3 months. So that's the individual mandate. What effect has the individual mandate had practically? We're hearing, although I haven't seen much of this, that some employers are feeling pressure to provide health coverage if they didn't before. So you've got a host of folks probably that were younger, healthier individuals that weren't required to have health care coverage and now are. So now they're looking to have that, to enroll. And whether that's through the exchange or through an employer or through coverage not provided on the exchange, they're looking for that opportunity. So you can expect that some employers that haven't provided that health coverage in the past are feeling that pressure. The other thing, obviously, and I think this is a natural consequence, is that the employers, the insurers, and the TPAs have all kind of indicated that enrollment is all up on the employer plans, and that's to be expected. What I don't know is at this point, is enrollment as high as we expected it to be? I'm sure there were projections on that. I'm sure it was difficult to project that, so I'm curious about that. Unfortunately, I don't have any insight into that for you. The exchanges also went live in 2014, as I'm sure you've heard, and it was well publicized that it had a bumpy start with the enrollment period last fall. They seem to iron out a lot of those issues. Remember that there are two main types of exchanges. You have the federally run and you have the state-run exchanges. States did have a choice on whether they wanted to establish their own exchange, and I think 36 states ended up electing not to. So 36 states are on federally run exchanges. So the two items in red there were also supposed to be effective in 2014. As we know, those were delayed. That's the employer mandate, also called the player pay penalty, also called a few other things. Those were pushed back into 2015. And so that's what we're going to cover mostly today is the employer mandate, and we'll also cover the reporting rules. I've got 2018 listed there because that's one of the last requirements that's scheduled to go into effect under healthcare reform. That's the Cadillac tax. So the employer mandate says you have to provide a certain level of coverage to avoid a tax or a penalty. The Cadillac tax says if you provide too good of coverage, then we're going to tax you on that too. I've got more on that in a bit. That's a ways out, so it's off most people's radar, plus there's some skepticism on whether we're going to see that go into effect in 2018 or not. Okay, so a key point to remember about healthcare reform is that you have to analyze the benefits independently of each other. And the bottom three bullets here are an example of why that's the case. So grandfathered plans are exempt from only certain portions of healthcare reform. They have to comply with certain parts of the law, and they don't have to comply with other parts. On grandfather, we typically use that term to describe something that pre-exists, a law change. And so what the law does is it recognizes that some of those pre-existing things, in this case it's a plan, they don't have to comply with those law changes going forward. But here, like I mentioned, grandfather status only gets you a partial pass under healthcare reform, and so you'll still be subject to some part of the law. And if you're sitting there thinking, wait a minute, we had a health plan before healthcare reform, are we grandfathered? If you're asking that question, the answer is probably not. Employers had to do certain things to notify, certain things to preserve that status, like notify their employees that they are grandfather status. And even if you did provide some of that notice, certain plan design changes over the years can eliminate that grandfather status. So the point here, again, is just that even though your grandfather plan, you have to look at each healthcare reform law to see whether you need to comply with it. The second bullet, small employers, there's not a uniform definition of small employer under healthcare reform, unfortunately. So we don't have certain employers that if you're small, you're exempt from laws A, B, C, and D. It's just not the way it works. So for instance, in player pay, small employers are generally defined as 50 employees, although there's a transition rule there that we'll cover. 49 employees or less, 50 and above, you're not a small employer. And then also, for instance, like in automatic enrollment, which isn't yet effective, there's a different small employer definition. So I think that's either 200 or 250 employees, can't recall, but just to give you an example there. And then finally, compliance with one law doesn't necessarily mean compliance with other laws. So that's really important to understand because there are certain laws, and the example here is waiting periods and player pay, that cover kind of similar topics, like how long can you exclude an individual from coverage? Under the rules, you may do enough to comply with one law only to find that you violated the other. You might think that they coordinate, but in a lot of circumstances under healthcare reform, that's not the case. So that's just a word of caution. Okay, player pay. So the big picture here is, before we get into the weeds, I think it would be a good idea to give a big picture view. And so if you kind of think about it this way, if in any month you have a full-time employee that goes to the exchange for health coverage and receives a premium tax credit, then there's going to be a penalty if the applicable large employer, again, ALE means they're subject to player pay, doesn't offer certain coverage for that month. So remember, this is also considered a shared responsibility tax. So if the employer doesn't offer coverage and the government has to subsidize that coverage via that premium tax credit, then the idea is the employer has to chip in. So you can almost picture how this happened, right? When they were designing healthcare reform, they thought, let's ensure access to health coverage to everyone. Well, that might be expensive. Okay, well, we'll require that all individuals have to have health coverage. That will force people without insurance to get insurance and coverage, and that'll help balance the risk-sharing pool. Well, we can't require people to get health coverage, so okay, we'll tax it. Oh, well, all right, that might work, but that still won't cover all the costs. Okay, well, we'll require the employer to, or we'll incent the employer to provide coverage to their employees, and then the government will subsidize everyone else. So that's kind of the system we ended up with, and it seems somewhat straightforward. But as you know, when you're crafting a law that applies to employers, it's really difficult to craft a one-size-fits-all approach. And so that's why we have, some employers might have union employees, some employers might have seasonal employees, some might have lots of part-time employees. That's where we get the complexity in the law. But this slide is just kind of to give you an overview of the big picture of why we care about shared responsibility or player pay. So player pay, as I mentioned, it only applies to applicable large employers. So that means 50 full-time employees or full-time employee equivalents or more. And then there's, like I mentioned, there's a transition rule. What's an important thing to note is that you do this analysis on a controlled group basis. So related employers will count for this purpose. So you can't structure your entity around application of the law. So basically, if we have Division A and Division B and they're separate legal entities, they're both owned 100% by a parent, and each has 30 full-time employees, both employers will be subject to the law. They'll be considered an applicable large employer. That's a type of law that we have in a lot of our benefits type situations. Basically, it's a law that's required to avoid somebody structuring themselves around application. One other big picture to point out on player pay, employers do need to be considering compliance today for a couple reasons. One, and we'll talk about it when we talk about how you determine your full-time employees, but your look-back period might be counting hours of service and time worked by your employees right now. The other thing to keep in mind is that if you don't take a careful look today, you might make the mistake of not covering somebody you're supposed to, which could result in penalties. But the reporting obligation for player pay, the first report that will come from you isn't required until 2016, even though it's effective generally in 2015. What that means is you might not discover that you didn't cover somebody until well into 2016. At that point, you could have accrued, over a year's worth of player pay penalties. So just another thing to keep in mind. Okay, so this is just a quick slide on the timeline of how we got to where we are in player pay. So we've got 2010, that's when the statute was enacted. And then a year ago, last January, that's when we received proposed regulations. And last July is when they announced that they would push it back from 2014 to 2015. I have to laugh because the delay was announced in a press release from Treasury, and it was titled "Continuing to Implement the ACCA in a Careful, Thoughtful Manner," which really is code for we weren't ready to implement, and there's going to be a delay. So, and then also here we have February 2014. That's when the final regulations were issued under player pay. So when is it effective? I've kind of alluded to this already, but for employers with 100 full-time employees, including full-time equivalents, it's effective starting in 2015. If you're in a mid-size employer where you're 50 to 99, you may be able to satisfy transition relief. There are conditions you have to satisfy, but if you do, you won't have to comply with player pay until 2016. And then again, 49 or less, that's not an applicable large employer, not subject to the law. Who is a full-time employee and full-time equivalent for ALE purposes? Full-time employees, 30 hours a week or 130 hours in a month. How you determine your full-time equivalents is you take all of your non-full-time employees, you add up all their hours, and then you divide that by 120, and that gives you kind of a month full-time equivalent number that you can add to your full-time employees and determine whether in that month you had 50 or more. And the way this works is you add all your months together and then you average that out, and then that's based on the prior calendar year. So for next year, for 2015, it's going to be based on your hours and your full-time employees in this year, in 2014. And you average it out, and if you're above the threshold, you're subject to the law. If you're below, you're not. And that's year to year, something that you have to monitor if you're on that threshold. So we talked a little bit about who it applies to, when it applies, and let's talk a little bit more about the specific penalties. So the sledgehammer penalty, as some people have referred to as kind of catching on, is also called the subsection A penalty. And you have a penalty here if the employer doesn't offer minimum essential coverage to substantially all of its full-time employees, and you have one full-time employee that goes to the exchange, gets health coverage, and receives that premium tax credit. The penalty is $166.67 per month, and this is why it's called the sledgehammer penalty. It's because it's applied on each full-time employee of the employer. So if you violate it, you have to count all of your full-time employees, and then whatever number you arrive at, say it's 150, you would take 150 times your $166.67, and then for each month that you violated the subsection A penalty. So that's the big penalty. How this might happen is you could have an employer that doesn't offer any coverage, or if they offer coverage, it's not minimum essential coverage. Or you could have an employer offer minimum essential coverage, but they don't give it to substantially all of their full-time employees, that underlying word in the test above. So what that substantially means is 95% generally. You have to offer it to at least 95% of your full-time employees, but there's a special rule for 2015, that margin of error is 30%. They're giving you kind of a cushion for the first year in case there are some mistakes made. It's important to note that affordability and minimum value don't matter for the subsection A penalty. So those don't really have a bearing here. The other penalty is what's been referred to as the tackhammer penalty. And so this penalty happens if an employer doesn't offer coverage, or they offer coverage which is either unaffordable or doesn't provide minimum value. And then you have that typical trigger where the full-time employee goes to the exchange for coverage and receives the premium tax credit. So this penalty is $250, so that's kind of odd that it's the tackhammer and it's more, but this penalty only applies on each full-time employee for each month that they're not offered coverage, and they go to the exchange and get the premium tax credit. So much likely to be a much smaller overall penalty. Notice that there's no margin of error rule here. I do have employers that are taking an approach where they're covering a bulk of their employees, over 95%, and they have another, I guess is a thing I should have pointed out on the last slide, the margin of error rule. You can not offer coverage, and that can be intentional or unintentional and still take advantage of the margin of error rule. So what some employers are doing is they're offering coverage to everybody, but there might be a small class of employees they still don't want to give health coverage to for one reason or another. and they say that that's less than 5% of our population. We're not worried about the subsection A penalty. Most of those employees might be part-time employees. We're not going to offer them coverage, and if they end up working enough to be considered a full-time employee and they go to the exchange and they get a premium tax credit, then we'll pay the penalty. So that's just one thing to keep in mind there, that the margin of error can get you out of the subsection A, the sledgehammer penalty, but not the tackhammer penalty. Okay, minimum value and affordability. What do those mean? This, again, relates to the tackhammer penalty. Your coverage has to be affordable, and it has to provide minimum value if you're trying to get out of the tackhammer penalty. A plan offers minimum value if it generally covers 60% of the cost of coverage, and it's affordable if it doesn't cost more than 9.5% of the employee's wages. And there are safe harbors on how you come up with what the employee's wages are. There's the W-2 method, there's a rate of pay method, and then there's a multiplier of the federal poverty line. I'm not going to get into too much more detail on minimum value and affordability more than that, other than to say that there are other benefits that you can offer which will affect that analysis. And you want to make sure if it's your broker or is there somebody else that's running this analysis on whether your plan meets minimum value and is affordable, that they consider these types of things. So the first is a health risk assessment. I'm sorry, that's another acronym. I got confused. The first is the HRA contribution, which is a health reimbursement arrangement. So these are basically, it's a pool of money that the employer makes available so that the employee can choose to use it and reimburse certain health expenses. These are problematic if they're not structured in a particular way under another law of healthcare reform. So generally they need to be integrated with your health coverage, but if you do have an integrated HRA, then that contribution might count towards minimum value, and it could count towards affordability if you can use that amount to reduce premium expenses. The second is HSA contribution, which is a health savings account. This is an individual account that somebody can set up if they have qualifying high deductible health coverage and they don't have other disqualifying health coverage. The amount that you contribute to an HSA can count towards minimum value, but not affordability, because by law, HSAs can't be used to fund premium expenses. And then finally, I have wellness incentives. So wellness incentives are programs that are designed, wellness programs are designed to encourage certain healthy behavior and kind of in an effort to reduce the cost under major medical plans, typically why you see them instituted. Other reasons might be the employer could be more paternalistic and they're simply trying to provide, promote the better health of their employees. There are lots of different designs of wellness programs, but most provide a reward or surcharge of some sort, and it could be for something like participating in a health risk assessment. It could be like achieving a certain BMI count under biometric screening. The most common one is probably tobacco use. What the guidance has told us is that if you have a wellness reward that's related to tobacco use, that can count towards minimum value and affordability. Okay, kind of back to the big picture for a second here. What do employers have to do to avoid a play or pay penalty? They have to provide all their full-time employees with affordable health coverage, which provides minimum value. So what if you're an employer who doesn't provide coverage to all your employees? How do you know who your full-time employees are? And right back into the weeds we go. So this is a full-time employee for penalty purpose should be distinguished from a full-time employee for applicable large employer status purposes. Although they're similar, the rules are a little bit different. We had that general rule that a full-time employee is someone who, on average, works 30 hours or more in a week. And this determination is made on a month-to-month basis, which is important to notice because you might have a group of employees that are full-time employees in 1 month and not full-time employees in the next month. And the IRS has given us 2 methods on determining who your full-time employees are in any given month. That's the monthly method and the look-back method. In the next couple slides, we'll get into a bit more detail on this. Okay, so if you're an employer who doesn't provide coverage to each and every one of your employees, this is the monthly method is really the Russian roulette method of determining who your full-time employees are. And that's because under this method, an employer won't know who its full-time employees are until the end of the month in which the employees have worked, and you've calculated up the average of the hours to see if they've worked 30 hours a week. And it's an important point to remember that an employer's offer of coverage for player pay penalty purposes isn't effective for a month unless that employee could have had coverage for each and every day of that month. So you can't say, it looks like Joe is going to work 30 hours this month, 30 hours a week this month on average. Let's give him an offer of coverage on the 31st just to avoid the player pay penalty. That strategy won't work. I've noted here in one of the bullets that there is a limited non-assessment period that applies with this method. So you could have an employee that works 30 hours in a month and becomes a full-time employee, and if you didn't offer them coverage, that employee could have gone to the exchange, received a premium tax credit, and you could be subject to a penalty. This says that if you provide them coverage within a certain period of time, generally the first day of the fourth month following the month in which they satisfy that full-time employee status, then you won't incur a player pay penalty. So even though an employer won't know who its full-time employees are in advance by using this method, who might want to do this? So I'll start with the bottom bullet here. Some employers might take a retirement plan approach to eligibility in their health and welfare plan. Remember, in retirement plans, if you have a participant that meets the eligibility requirements, and they're not otherwise excluded from the plan on the basis of classification or something else, then they generally continue to be eligible for to participate in the retirement plan no matter what their future hours are going forward. There are certain contributions, of course, in the retirement plan that may have allocation conditions based on future working hours and things like that, but strictly from an eligibility standpoint, once they're in the plan, they're in. So an employer might say, that's what we're going to do. That can create certain hardships in the health and welfare context because, you take that approach and then somebody drops down to 20 hours a month, depending on how highly comped they are, it might be difficult for them to meet their contribution requirements under the plan. The other two bullets are kind of along the same lines, which is if you're an employer that's decided to pay instead of play, or you just decided to pay the penalty, depending on the facts and circumstances of your business, using the monthly method versus the next method we're going to talk about, the look-back method, may reduce the number of full-time employees you have. And if that's the case, then it could save you on the tax that you'd have to pay. And then, employees that provide coverage to all employees that have very few variable hour employees, I can think of another reason why they might want to use this method, because the look-back method administratively is somewhat difficult. And there are some other burdens associated with it that we'll talk about in a second. But if you just want an administrative ease of let's count up the hours at the end of the month and see whether we have full-time employees for this class of employees, then this might be attractive to those types of employers. Okay, so again, trying to stay at a fairly high level. So the look-back method allows you to know who your full-time employees are going into any month. So employers using the look-back method can predict who their full-time employees are in the next month, and they can offer them coverage so they can avoid a penalty. And I'll mention right now that you can use look-back method and the monthly method for different groups of employees. There's limits on using them for certain classifications versus others, but you do have that ability to pick and choose which class method you want to use for certain classes of employees. So basics on the look-back method, we've got a measurement period, and that's the period in which you're looking back to assess whether their hours were enough, 30 hours on average, again, to be considered a full-time employee. So that measurement period is that can be between 3 and 12 months, and then based on how that comes out, the employee is either a full-time employee or not a full-time employee for the stability period. As with everything, there are exceptions to that rule. So there are instances where you might have to grant somebody full-time employee status before they would otherwise, before their stability period would have expired, but those are kind of one-off exceptions. And I will also note that you can have different measurement periods for new hire variable hour employees than with your ongoing employees. And one of the reasons an employer might do this is, so variable hour just means it's an employee that's reasonably not expected to work 30 hours a week at the time they're hired over that initial measurement period. And so if you have these folks come in, you can take up to 12 months with them to decide on whether to offer them coverage. And if you do that, if you have perhaps high turnover and a lot of part-time employees, that may significantly reduce the amount of people that an employer has to offer health coverage to avoid a penalty. Okay, so who might use the look-back method? Again, it's employers with lots of variable hour employees, and an employer might use it if they want perfect certainty on full-time employee status. And those employers are probably the ones that will be tying their eligibility in the plan to the look-back method. Employers that might not want to use that, they don't want the obligation to offer coverage when not a full-time employee. So that problem again, where you have an employee that gets full-time employee status, and during the stability period, or maybe before even, they drop their hours significantly. They don't have the money to pay for the plan contributions. That can also cause cafeteria plan concerns related to a change in status, because they'd still be eligible under the plan. Generally, if you lose eligibility under the plan, that's a permitted change of status under the cafeteria plan to allow you to change your pre-tax reductions. In this instance, it wouldn't be because there isn't a loss of coverage. So some issues there. The other big reason that's kind of coming to the forefront of people's minds is it can be difficult to administer and document the look-back method. So one of the issues is plans aren't required to spell out the specifics on how the look-back period is going to work in their plan document if they're tying eligibility in the plan to a look-back method. But they're not completely off the hook, because these are health plans subject to ERISA. You have the reporting requirement under ERISA. The disclosure requirement under ERISA of an SPD, and the SPD has to describe eligibility, and it has to be done in a manner that's likely to be understood by the average plan participant. And the complexity of using the look-back method and the nuances that come along with that, when you have an employee that goes from being variable hour to non-variable hour, and there are other examples, there's lots of scenarios that can play out that there are rules for under the look-back method, but figuring out how to craft language in your SPD that describes that in a manner that's likely to be understood by the average plan participant, that's going to be the challenge that's coming up. I do want to go back, because I said that plans don't have to spell out the specifics on the look-back period in the plan document. But what we're recommending is that employers, if they're using a look-back method for eligibility, that they say something along the lines of, employees who average 30 or more hours a week are eligible to participate in the plan as determined in the attached policy. And then the policy would set forth your look-back method assumptions. We're using a 12-month ongoing measurement period and a 12-month initial measurement period. We're using this many days for administrative period, so forth, that type of thing. And depending on how you craft that policy, that might be an opportunity for you to use the SPD as well. So the SPD could reference the policy, or it can be attached to the SPD. That's something that employers will have to decide. Okay, I did want a quick slide on some player pay strategies out there that you may have heard about. So the popular one, and I think there's even been an article in the Wall Street Journal on this, is the skinny plan design, as it's called. So the idea behind this is you offer a bare minimum amount of coverage that amounts to minimum essential coverage, because remember, that's what you have to offer to avoid the subsection A penalty. But it's not affordable, and it doesn't provide minimum value. So in other words, it's very expensive to the employee, and the plan's not going to provide much of a benefit. So if you offer the skinny plan, the idea is we're not going to get hit with the sledgehammer penalty based on all of our full-time employees, but we'll pay the subsection B penalty on those folks that go out to the exchange and get a premium tax credit. The thing I want to caution about is that the agencies know that these skinny plans are going on, and while they haven't quashed it yet, they're saying that they're looking into them more. It doesn't mean that the agencies are ultimately going to conclude that they're abusive or that they skirt the rules of, beyond what it was intended, but they're looking at it. So it's possible they could come out and say, you can't do these anymore. And so if you're using one of these approaches, you need to have a plan B, and you also need to know that you're assuming some risk with this approach. So, it's perfectly possible that the agencies will come out and say the skinny plans don't provide maybe minimum essential coverage or something like that. And they don't give you time to put in a new plan to comply with their ruling. And so there could be penalties that you've accrued there. So there's some risk that has to be assumed if you're going to go after one of those strategies. The other strategy that you may have heard about, and this is kind of a variation off of the skinny plan, but the idea is to offer a plan that is affordable and provides minimum value to your high paids, and then offer the skinny plan to your low paids. So hopefully there's a lot of you out there thinking, are there discrimination concerns with this approach? And there could be. Remember, self-funded plans are currently subject to discrimination rules under Code Section 105H, and they have been for a long time. Insured plans are not yet subject to discrimination laws. So you may have a temporary window of ability to do something like this. But I caution that too, because one of the laws under healthcare reform extends discrimination rules similar to the 105H discrimination rules to insured plans. And that was actually supposed to be effective, it may have even been 2010, but it should have been effective already. We're waiting on final regulations to make that effective. So kind of the same idea with the issue before is if you're using this approach, you need a plan B, and you need to understand and assume the risk is associated with that approach in case this would be a problem for you. And then the last thing I have noted here, I listened in on a conference last week that was discussing this issue, is that there are some commentators out there that believe offering this kind of two-tiered system could potentially implicate an ERISA 510 claim, which is basically the employer interferes with a protected right. So that's just another risk item to keep in mind. Okay, so that's player pay. And now we're going to get to some of the other issues under healthcare reform, and then, like I mentioned, executive comp at the end. So reporting rules, we got final regs on these. There's two types of reporting generally. It's Section 6055 and Section 6056 reporting. The 55 reporting reports on minimum essential coverage. And this is what you have to report to the government on so that they know whether an individual should be subject to a penalty under the individual mandate. And this return is filed much like, both of these are much like kind of a W-2 or informational return. The deadlines are very similar, if not the exact same. And there's two components to it. One is you report to the individual or the employee, and the other is you report to the government on both. this 55 and 56 reporting. So who has to report on the minimum essential coverage reporting? If you're an employer that doesn't offer any health coverage whatsoever, there's not going to be a reporting obligation because you're reporting on the coverage. If you have an insured plan, it's going to be the insurer that reports under 6055. If you have a self-funded plan, generally that's going to be the employer, although there is an exception for multi-employer plans. Multi-employer plans are plans that are maintained pursuant to a collective bargaining agreement, so union plans in which multiple employers participate. And again, you have to file that with the covered individual, not the employee. So we're talking belly buttons here, and the government. And so Section 56 reporting is what's needed for the player pay penalty. This lets the government know who your full-time employees are and whether they were provided coverage. In this instance, since it's linked to player pay, it's only the applicable large employer that has to report. So if you're a small employer and you offer health coverage, but you're not subject to player pay, you'd be reporting under 55, or maybe your insurer would, and then under 56, you wouldn't have a reporting obligation. And again, this is filed with two parties, but in this instance, it is the full-time employee and the government. Okay, so this next slide I'm not going to spend any time on, but this kind of gives you an idea of what's required under the 6056 reporting. I believe they've issued forms on that reporting too, so you can probably go out and Google the IRS website to figure out what forms you're going to be filing. I think it's supposed to be done on two types of forms, but those are available on the web. The first bullet here, alternative reporting methods. This is just to note that there are alternative reporting methods under 55 and 56 reporting. I'm not going to go into detail on those, but those are out there if it's something you'd like to look into. Penalties for failure to report. So we have our typical reasonable cause exception that we have on a lot of reporting. So if there's a reasonable cause to explain why you missed a reporting deadline or something, then there's relief there. And then there's this good faith efforts exception, and I think this is unique to the reporting that's required here. So 6056 and 6055. Just the law is becoming effective. So if you make a good faith effort to comply, you're likely not going to be subject to penalties. The one thing to note here is that failure to file is never good faith. So that's not going to get you out of a penalty if you miss a filing obligation. Similar to the other informational reports that you have to file, like on a W-2, 1099 and such, the penalties are two-tiered structured. So there'll be a penalty on the return that was supposed to go to the individual or the employee, and there'll be a penalty that goes on the return that goes to the IRS. So those can get expensive for the large employers. Okay, so the 90-day waiting period law under healthcare reform. So plans are not permitted generally to exclude an otherwise eligible employee from health coverage for more than 90 days, and their exceptions are below, and I'll cover those in a second. But I want to focus on the otherwise eligible is a key word. So you can still exclude employees based on substantive conditions like Department B employees, Division X employees, and that's fine. That's not going to violate the 90-day waiting period because they have to be otherwise eligible. So to take advantage of we talked about it briefly, the player pay limited non-assessment period, where you have that if an employee gets full-time employee status, then you have a period of months in which to offer them coverage, and if you do by a certain time period, then you're not subject to the player pay penalties. For new hire full-time employees, there's a limited non-assessment period too. You have a period of months in which you have to give them coverage, and if you do it by a certain time period, then you're not going to be subject to the player pay. This is an example of how player pay and the 90-day rule don't exactly gel, because that first day of the fourth month following may be longer than 90 days. So you might be doing something to comply with player pay, only to find out that you imposed a waiting period that was too long under the 90-day waiting rule. So we have some guidance on that. The regulations that were issued in February were part final and part proposed. The proposed part was on this issue of orientation periods. So the proposed regs said, and we do, by the way, have final regs on those, which really didn't deviate much from the proposed in the last month, but they say that you're allowed an orientation period for new employees of up to a month. So what that means is, if you have an orientation period that tolls the start of the 90 days for the 90-day waiting period law, and you might be able to coordinate that first day of the 4th month under player pay with the 90-day rule. But I want to caution a few things. One here is that the orientation period, calculating that 1 month's never, it's not as simple as it seems. Without getting into too much detail, you basically take the same day of the following month and you subtract 1, and then there are special rules for when you can't do that. But the other thing that I really wanted to hammer on is that I think there's a misconception out there that these regs came out and some folks said, oh, we get an orientation period. Now we can, that was meant to coordinate player pay with the 90-day rule. And I don't think that's the case. So the final regs on the 90-day rules talk about the orientation period having to be a bona fide orientation period. And so without some level of substantiation for that orientation period, like an evaluation or a review of your employees, training, something along those lines, I think you're stuck with the general 90-day rule. So what we've seen some employers do is if they're imposing a waiting period based on a number of days, they might go with something shorter like 60. Okay. And then the other two exceptions, you've got the cumulative hours of service exception. So that's up to 1,600 hours of service. Basically, you can say you have to satisfy 1,600 hours of service before that 90-day period starts. That's fine, but again, that doesn't necessarily correlate with player pay. Somebody can be a full-time employee well before their 1,600 hours of service is met. So you could end up with a player pay penalty even though you wouldn't have violated the 90-day waiting period law. And then this last bullet on satisfaction of hours over a period of time condition, this is really designed to help coordinate those variable hour new hire employees that you're allowed to exclude for up to 12 months under player pay. So that allows you to, there's a coordination example, I suppose. Okay, fees. So this one's timely, the PCORI fee. This one is due, actually, you have to file a Form 720, and that's due at the end of this month. This fee applies to insurers, so insurers have to pay it for insured plans. For self-funded plans, it's the plan sponsor that has to pay it. Be careful, though, if you provide insured major medical, that you don't have some other self-funded plan that would be subject to the requirements of this fee. One example is an HRA. It's something you want to look at to make sure if you have to pay this fee that you do. It's $2 per covered person. Again, that's not just employees, that's the dependents and everything. There's different methods they allow you to determine how many covered employees you have to use to calculate your fee. One, I think, is the 5500 method. There's a snapshot method, and if you want more details on that, feel free to reach out to me. This fee is tax deductible, and it's not a plan expense, which what I mean by that is if you do have plan assets, you can't use your plan assets to pay this fee. And again, as I mentioned, you'll file this on the Form 720. That's a form that has to be filed quarterly. If you don't otherwise have to file the form, it's still filed on the second quarter Form 720, but that's just a point of clarification. Again, that one's due soon. The other fee that I mentioned is the reinsurance fee. So this, again, is paid by the insurers of the insured plans and the plan sponsors of the self-funded plans. There's a little controversy over this fee. The purpose behind the fee is it provides reinsurance to insurers, I think under the exchange, not sure on that part, but it provides reinsurance to those insurers because because of the elimination of pre-existing exclusions, there's a whole bunch of folks that are coming into health coverage and insurance that are high-risk individuals. So the idea behind the reinsurance fee is it allows the insurers to have confidence in offering coverage on the exchange. This fee is the controversy, I'm sorry, I didn't get to it. The controversy is that, okay, if it's for the insurers, why are the self-funded plans having to pay for that? But nevertheless, it applies to self-funded plans. The fee is variable, and it's determined from time to time. They've announced the 2014 and the 2015 amounts. It's $63 per person in 2014 and $44 per person in 2015. As far as when you pay, you're supposed to provide enrollment data to HHS by November 15th of every year. They'll send you an invoice by the December 15th, and then you have 30 days from that invoice. The second installment's due in the fourth quarter of the following year. Like the PCORI fee, this is tax deductible. Unlike the PCORI fee, you can pay this from plan assets if you have those. All right, I just mentioned this, but just to reiterate, pre-existing condition exclusions aren't permitted for the plan year that begins on or after 1/1/2014. So if you have a late plan year, you may not have adjusted your plan for that yet. You want to make sure that you comply, especially insurers will be on top of that, but if you have a self-funded plan, you want to review the plan document to make sure that you've got that covered. The good news is that means is that no more HIPAA certificates of credible coverage will need to be issued after 12/31/2014. That's probably not a big consequence to a lot of employers, as they're likely relying on their TPAs or insurers to handle that for them. But at least there won't be a penalty for failure to provide if that responsibility is borne by the employer. The next item, health reimbursement arrangements. So I touched on this earlier, but this is not a new requirement under healthcare reform. They have to be structured in certain ways. The issue here is under healthcare reform, health plans aren't allowed to place a limit on annual and lifetime. I'm sorry, they're not allowed to place annual or lifetime limits on certain essential health benefits anymore. And an HRA, by design, since it only allows you a certain amount of money, typically up to $10,000 per year or $2,000 per year to pay towards health expenses, medical expenses, it violates this rule. There are ways you can structure it so that you can still offer an HRA, but it has to be, the most common is to be integrated with your major medical. Again, remember, if that's insured, you want to make sure you pay the PCORI fee if that's applicable. Retiree-only plans, you're allowed to have HRAs, or it can fund just an accepted benefit. Wellness programs, so I kind of touched on this earlier. These are plans that are trying to incent certain healthy behaviors. Healthcare reform changed the limits that are allowed under the HIPAA non-discrimination rules. Typically, you're allowed to provide a reward or surcharge under a wellness program of 20%. Now you're allowed to go to 30% for your non-tobacco programs and up to 50% for your tobacco program. So if you had $1,000 cost of contribution for an insured plan for a certain level of coverage, and you'd be able to offer a reward. If it was tobacco-based, you'd be able to offer a reward of up to $500 on that premium or a surcharge, however you decide to structure that. Some employers, so we've heard that since you're allowed to use the tobacco reward in the wellness program towards your affordability or your minimum value, they are being pretty aggressive on the tobacco rewards that they're using, and they're using that as typically as a premium reduction to help them satisfy the affordability requirement. Remember, that appears under the TACHAMR or the subsection B player pay penalty. Routine patient cost. Most plans provide that they won't cover health expenses associated with clinical trials. Typically, this is done through a clause which excludes experimental or other similar types of procedures. This new healthcare reform requirement says that if the plan would have covered a cost, but for the fact that it was incurred in a clinical trial context, then the plan has to cover it. Non-discrimination rules, I already mentioned that. Code Section 105H already applies to self-funded plans. Insured plans, that's coming. We don't know when. They've requested comments, but it's not unusual for these things to be delayed a while. The Cadillac tax, again, this is the tax that will be effective or is scheduled to be effective in 2018 for employers if they provide coverage which is too good. This is one of the only areas of healthcare reform where there's bipartisan disapproval of this requirement. So there's a ton of commentary out there that this is going to go away or it'll be substantially reformed at some point. So stay tuned. People have been saying that it will go away for a while. For a few years now. We still have it, so I don't think that's necessarily an indication. I just don't think Congress is going to spend the time on it until it gets closer to 2018. Some employers are starting to consider it in their planning, though. It probably was enacted. I'm not 100% on this, but my gut is it was enacted to deal with some of the non-discrimination rules that are out there. If you're providing a very nice plan to your execs and nothing to the low paid, then that might make sense to tax that, along with a lot of other executive comp reform that we've had. Individual health insurance. This is an issue particularly for small employers. We see doing this, but there's been some guidance that was released. It was a little bit under the radar last fall. Basically what it says is that the employer can't contribute to an employee's individual health insurance policy on a pre-tax basis because it violates certain healthcare reform issues. It's the same issue I talked about on the HRA, where you're imposing an annual or lifetime limit. That's the view of the agencies, and so your ability to do this on a pre-tax basis has really been taken away. And I'll note that it's not quite clear yet, but on an after-tax basis, it looks to be substantially limited too. The most conservative thing to do is, if you're going to provide a subsidy to your employees for individual health coverage, is just to give them additional compensation. They can choose to use that on individual health coverage if they want. If they don't, then they have grocery money. There are also some state law concerns there too. Some states don't like the employer, contributing to individual policies for the concern that they'll take it out of the individual rules under the state laws and into the group rules. The exchange notice, again, just a reminder, this was first required last fall. You have to provide it to your new employees within 14 days of hire. It doesn't matter whether or not you offer group health coverage, you have to provide this notice, but the silver lining is there's no specific penalties. If query, if you have a health plan, there may be some argument that there's a fiduciary obligation to provide the notice, but there's no specific penalties. So we're getting a little short on time, but I've only got a couple slides left. Health FSA carryovers. So this is new. Under your Health FSA, you have the use it or lose it rule for cafeteria plans, which says if you don't use your Health FSA balance by the end of the year, you forfeit it. They've given us another tool to deal with that, which says $500 can be carried over into the next year. If you have a grace period under your Health FSA, you can't use this together. You can't use the carryover rule with the grace period, so you'll have to pick one or the other. And then remember that if you're implementing a carryover rule, you have a high deductible health plan, and you allow pre-tax contributions to your HSA through the cafeteria plan, you'll need to coordinate that, because Health FSA eligibility will be considered disqualifying health coverage for the HSA, assuming that it's a general purpose Health FSA. Same-sex marriage, just briefly, the gist here for employee benefits is there's a law that gives a benefit to spouses, a federal law that gives a benefit to spouses, or spouses affect some aspect of the law or eligibility, something like that, then a same-sex spouse will be considered for federal law purposes a spouse. If you're in a state that doesn't recognize same-sex marriage, remember that the place of celebration rule applies for this purpose. So even if they were married in a state that recognizes same-sex marriage and came to perhaps your state that doesn't recognize same-sex marriage, for federal law purposes, they're still recognized as married and spouses. There's some interesting litigation risk here for health and welfare plans on whether to extend, whether some plans might offer opposite sex spousal coverage but not same-sex spousal coverage. That's a risky issue, and I encourage you to look at that more, because there's lots of lawsuits popping up on that, even though technically that may be permissible. finally, executive compensation. So this last slide is just on 409A, and just to let you know that there are some audits going on out there under 409A. And the slide title is a little misleading because although this kind of fits within the realm of executive compensation, it applies to anybody, not just executives. And deferred compensation is what's subject to 409A, and you have deferred compensation anytime you have amounts that could be earned in one year, paid in another. And so you've got lots of arrangements that could be subject to 409A. You've got deferred comp plans, employment agreements, separation agreements. I just want to remind everybody that you need to, especially with audits underway now, you need to review those, make sure that they comply or are exempt from 409A. And if they don't, you want to correct that. One of the issues and why you want to focus on correcting is you have certain time limits typically to make those correction errors as well. So thank you everyone for participating. I do have one question I'll respond to. It's, do you know when the Form 6056 is due? Top of the head answer, I think, is similar to the W-2. So the statement to the employee has to be provided by January 31st, and the statement to the IRS, and the return to the IRS has to be filed, I think, by the end of February, if you're filing non-electronic, if you're filing electronic by the end of March. Thank you, everybody, for your time, and I hope you learned something. If you have any questions, feel free to give me a call. My contact information is there. Thank you.